Hi guys, welcome to my channel, The Legal Affair, with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on employees, freelancers, and independent contractors. Please, of course, do remember to subscribe to our channel, The Legal Affair. You can follow us on social media, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. That's at attorney_bay. So, under South African law, there are quite a number of laws that regulate the employment space. So, for instance, this includes the Basic Conditions of Employment Act. There's the Employment Equity Act, there is the Labor Relations Act, and various other laws that regulate employment. Or the employment space. Employees also actually differ from freelancers and independent contractors, and the benefits that freelancers and independent contractors have also differ from those of employees. In the South African context, there are many companies that actually prefer people to be freelancers and independent contractors rather than employees. This is because companies actually have many or greater legal obligations towards their employees than they do have for freelancers and independent contractors. And there are more rights that are given to employees than are given to freelancers and independent contractors. So it is actually quite important for you to establish whether you're regarded as a freelancer or an independent contractor or an employee. This is, of course, because the rights of freelancers and independent contractors differ quite substantially from the rights of employees. So, some of the factors that you want to consider when differentiating rather between freelancers and independent contractors as well as employees. So, the number of hours an employee works is normally fixed. Employees do work prescribed to a certain number of hours when compared to freelancers and independent contractors who usually don't work a minimum number of hours. They set their own hours. Another factor that differentiates a freelancer and independent contractors, in many instances, freelancers are not always supervised, or they don't always report to someone when compared to employee who usually work under supervision and are also required to report to a senior or a superior. Freelancers and independent contractors also differ from the employee in the sense that employees are often given tools of trade or work equipment. In other words, so you're provided with equipment that you will need or work with, versus a freelancer or an independent contractor who isn't usually given work equipment. So there are quite a lot of factors that, of course, do differentiate freelancers and independent contractors. And as mentioned, of course, employees actually have greater benefits when compared to freelancers and independent contractors. Now, some of the benefits that accrue to employees that don't accrue to freelancers and independent contractor include UIF. So, on a month-to-month basis, employers have a legal obligation to pay a UIF contribution for their employees. And if it so happens that if you're an employee and your employment contract is, for instance, terminated, or you are retrenched during the period within which you were retrenched or your contract is terminated, you can actually claim from the UIF. And this claim is based on the fact that your employer actually has an obligation to pay a UIF contribution. When you compare this right, meaning the right to claim from the UIF, with freelancers and independent contractors, freelancers and independent contractors don't actually have a UIF contribution on a month-to-month basis like we see with employees. Therefore, they don't or are unable to claim from the UIF. So another benefit, for instance, that accrues to an employee that doesn't accrue to a freelancer or an independent contractor is maternity leave. So in many instances, employees take maternity leave anything from 3 months to 6 months. In some instances, companies do pay for maternity leave, and in some instances, companies don't pay for maternity leave. In an instance where your maternity leave is not paid for by your company, as an employee, you can actually claim maternity benefits from the UIF. When you compare that with freelancers and independent contractors, freelancers and independent contractors don't actually have a maternity leave benefit. So, in other words, if you're a freelancer or you're an independent contractor, should you opt to take maternity leave, there isn't any UIF claim that you would have when compared to an employee. So, like I said, many companies prefer to have people being a freelancer or an independent contractor rather than an employee, because employees actually have better rights when compared to freelancers. when compared to employees. So, like I said, the rights of employees differ substantially from those of freelancers and independent contractors. So, under South African law, we've had quite a lot of important developments in the space for freelancers and independent contractors, as well as employees. When it comes to freelancers and independent contractors, there's been a discussion paper that has been published by the South African Law Reform Commission, and in essence, this discussion paper is advocating or tries to achieve greater rights or benefits for freelancers and independent contractors, synonymous or similar to that which you'd see for employees. So this discussion paper proposes, for instance, that freelancers and independent contractors should have a UIF contribution. So should it happen that a freelancer or an independent contractor opts to have maternity leave, at the very least they can actually claim from the UIF as proposed by this discussion paper. Another proposal by this discussion paper is to incorporate maternity leave for freelancers and independent contractors, which is something that we see as a right for employees. Another important development when it comes to the employment space for employees is the Employment Equity Amendment Bill. So, as you may know, a bill is a proposed new law. So, we do know that it hasn't been a law that has come into existence, but it is merely a proposal. Now, the importance of the Employment Equity Amendment Bill is that it introduces a few new elements in the employment space. So, for instance, the bill proposes having a national wage commission. The bill also proposes having a broader definition of what is seen or regarded as a person with a disability. The bill also proposes a sectorial the bill also does propose having sectorial targets, meaning that in a certain space, for instance, in mining or in the energy space, you'd have a certain number of people that you'd want to target or to have as a minimum. For instance, having a minimum of 10 women or 10 men. So the Employment Equity Bill also proposes doing away with psychological assessments or assessments that are similar for candidates that are being considered for various posts. So we do know that there are quite a lot of important legal developments, but at this stage, those developments for freelancers and independent contractors, as well as employees, are merely developments. They aren't existing laws that have been amended rather, but there are proposed or proposals to have existing laws amended. Thank you for watching, and we hope you enjoyed your episode today.